All right, so let's start with the first one. It's called a durable power of attorney. It's called a durable power of attorney because it survives your incapacity. So if you sign it today when you're feeling fine, and then tomorrow or next week or next year you're not feeling okay, the power of attorney who you appoint will still be able to act on your behalf, okay? The power of attorney, sometimes people call it an agent. If I appoint you to go to the bank and write a check for me, you're my agent. So you may hear people refer to it as that. It doesn't take away your power to manage your own affairs right now. So as long as you're perfectly okay and willing and able to manage your own affairs, the power of attorney simply is a document that's sitting in your drawer that's not going to have any legal effect until you can't take care of your own affairs yourself. Now think about this. If you don't appoint somebody as your agent, and you become incapacitated and you can't manage your own affairs, and that could happen. In fact, according to the latest statistics from the National Association of Insurance Commissioners, over half of us are going to spend some time in a nursing home and be incapacitated, not be able to take care of our affairs, either physically or mentally. We're just not going to be able to pay the rent, we're not going to be able to pay the mortgage, we're not going to be able to pay the electric bill, we're not going to be able to pay the heating bill. Things are going to happen so that we're not going to be able to take care of ourselves. And when I always say it's going to be half of us, everyone says, well, those are pretty good odds, and you know, look at the person to the left, say, oh, it's going to be him, it's not going to be me, it's going to be you, it's not going to be her. But the truth is, you really don't know who it's going to be. And if you wait until you find out whether or not it's you, it's going to be too late. So you appoint somebody as your agent under this power of attorney who is going to pay your bills for you in the event you get sick. You still pay them while you're fine, but if something happens to you, this person steps into your shoes to take over. Now, if you don't sign this power of attorney, and you say, you know something, I want to roll the dice and I want to take a chance here and see if maybe I'm going to be in the half who just dies in my sleep one day and I'm perfectly healthy. Well, if you're wrong, then your family's going to have to go to court to get a guardian appointed for you. They got to go down to White Plains or there's a court up in Putnam County, depending upon where you live. And it's a very time-consuming, expensive, and invasive process. What happens is all of your family's history and financial matters and personal relationships has to be discussed in front of a judge. The court appoints someone to investigate your family, to look into your finances, to see what's going on. And then after they have a hearing in open court where other people can sit in and listen to your affairs, there's a hearing in open court, somebody will be appointed as your legal guardian. Now, if you're lucky, it'll be somebody in your family. If you're not, it'll be somebody appointed by the court. And it's going to cost thousands and thousands of dollars, and it's going to require your family to report to the court on an annual basis. They're going to have to show all the expenses, show all the interest income that you have, and someone from the court is going to have to review it, and it's going to be very, very burdensome for you. It can be avoided by having this durable power of attorney. Now, for lots of reasons, people don't sign these powers of attorney. One reason is they say, well, I don't know who to appoint as my agent, as my power of attorney. I've got 3 kids and I don't know who to appoint. So they become like a deer in the headlights and nothing happens because they don't know who to pick. Well, you can pick one of them. Let's say you have a child who lives close by and the other 2 kids live out of town, or you can pick the one who you think has the most financial sophistication. Somebody might be a banker and somebody else might be in a different industry where they aren't used to working with numbers. So you can pick whoever you want. You have 3 kids, you can pick one of them, or better yet, if you want, you can pick all 3. So if you have more than one child or you have more than one relative, and it doesn't have to be a child, it doesn't have to be a relative, it can be a friend, it can be your accountant, it can be an acquaintance, it can be anybody you want, okay? It just has to be a human being. You can pick whoever you want and you can pick as many people as you want. Now, it doesn't make sense to have 12 powers of attorney. I mean, let's be real. I think probably the most we've had is we've had a gentleman with 5 kids, and he wanted all of them to be on the power of attorney. He didn't want to slight anybody. So we're able to accommodate him. There's plenty of room to do that. Now, once you pick more than one person, you've got another decision to make. So you have a son and a daughter, and you want to pick them both as power of attorney. Well, do all decisions have to be made unanimously? Or does either one of them have the authority to bind you, to write a check, to go to the bank and take money out? You need to make that decision. Now, there's pros and cons of doing it both ways. If you have 2 people as power of attorney and you require both signatures, and one of them is out of town or is unable to sign, or for whatever reason is unavailable, and something needs to get done. Well, if you're requiring 2 signatures, then you're not going to get it done until the other person is available. So it may handcuff the agents at a time when they actually need to act on your behalf. A benefit of having 2 signatures is if you're uncomfortable giving somebody so much power where they can go to the bank and take out money on your account and write checks, and you want to make sure there's a checks and balance. Or sometimes it's not about whether or not you trust the person. Let's say the brother and sister don't get along, your 2 kids, and they don't trust each other. So they're more comfortable being involved on a basis where joint consent is required. So some people like to know that 2 signatures are required. We find that about 3/4 of the clients choose to have each agent under the power of attorney act independently so that only 1 signature is required. Because if you really trust the kids and you don't want to handcuff them, it doesn't matter whether it's the son or the daughter who signs. Just pick, pick the one who's readily accessible on the date that the check needs to be signed, and that makes life a lot easier for people. Now, one of the things people forget about with the power of attorney is it dies when you die. So if you have a power of attorney and you pass away, the person who you appoint under your power of attorney has no authority to act on your behalf. The only one who can act on your behalf when you pass away is the legal representative of your estate. You've probably heard the term executor. An executor is what happens when you die with a will.